Good day from me, Adv Nadene Badenhorst, for SA's legal counsel. Last week, 4SA attended at the Chatsworth Equality Court for the hearing of the case against Bradley Chetty, a young evangelist who was taken to court by the South African Hindu Dharma Sabha for sharing his testimony of how he came to believe in Jesus. The Hindu organization asked the court to order Chetty to stop making statements which they consider to be offensive towards Hindus, also to do 200 hours of community service, and also to pay 1 million rand, later reduced to 200,000 rand in damages. Now, because an adverse judgment in this case had the potential to shut down the freedom of all persons of whatever faith to freely preach, teach and share their religious beliefs, 4SA intervened in the case as a friend of the court to make very sure that freedom of religious speech remains protected. Now, this is particularly important since the Quilani judgment in the Constitutional Court has now made it clear that just because speech is hurtful does not make it hateful. True hate speech, which is prohibited in our law, has to amount to the advocacy of hatred that also leads to an incitement to cause harm. At court on Thursday, the magistrate once again strongly encouraged the parties to consider settling the matter, particularly in view thereof that the matter has been ongoing for 2 years already, and there also was the possibility of a further postponement, therefore further legal costs, in circumstances where one of the attorneys had fallen ill on the day of the hearing. Now, after a number of hours of negotiation, an amicable settlement was reached, including the following. 1. Chetty made it very clear that absolutely no malice or offense was intended by his testimony and prayers, and in particular that he did not intend to cause anyone hurt or harm. Number 2, nonetheless, and even though he's done it 2 years before already, he apologized to anyone who may have been subjectively offended by his testimony and prayers. Number 3, the parties acknowledged that the Constitution protects the fundamental right to profess, including through teaching and preaching, and also to practice one's religious convictions and beliefs as one chooses, and that includes respecting the rights and dignity of people who hold to different convictions and beliefs, and also not making statements that go outside the limits of the very broad right to free speech. The settlement specifically did not include any community service hours or payment of any damages as initially asked for by the South African Hindu Dharma Sabha. This is a good outcome, not only for Chetty, but for all people of whatsoever faith who, in terms of the Constitution and as recently confirmed by the Quilani judgment, have the fundamental right to freely share their religious beliefs, even if others do not like it, do not agree with it, or find it offensive. Religious tolerance is a two-way street, and if we expect others to be tolerant of our views, we ourselves have to be tolerant of their sometimes contrary or even offensive views. This is what it means to live alongside each other in a diverse and pluralistic society. For more about this and other matters, follow us on the 4SA website or on Facebook. Until next time, goodbye.